Major Supreme Court ruling.
Major ruling involving the Second Amendment.
Supreme Court has just issued a major ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
All right, strap in. Rolling into this week, I honestly thought the Department of Justice was finally going to cool it. After all the pro-Second Amendment talk they've been throwing around, I figured we were about to see a little daylight. Instead, they dropped a court filing so out of pocket that every gun owner I know froze mid-scroll like, hold up, what did they just say? What world are we in right now? What's good, folks? This is Tommy from the Armory, and today I'm breaking down exactly how Pam Bondi's DOJ just flipped the table on gun owners, and why this situation cuts way deeper than most people realize. Before we dive in, do me a solid, smash that subscribe button, tap the bell, hit all the buttons down there. You don't have to, but it keeps this train rolling and lets me keep putting out this kind of no-nonsense gun talk for y'all. All right, enough of that. Let's get back to it, because they swerved hard. The big promises. At the start of this year, every gun owner I talked to was hearing the same thing on loop. Big wins were coming. National reciprocity was back on the table. Constitutional carry expansion was getting hyped. People were whispering that the NFA tax was finally about to get gutted. You had folks in D.C. talking about rolling back old regs and putting the ATF on a tight leash. And a lot of us thought, all right, bet, this might actually happen this time. Then President Trump taps Pam Bondi to run the Department of Justice and sells it as the most pro-Second Amendment DOJ we've ever seen. On paper? That sounds wild, in a good way. You've got the One Big Beautiful Bill Act signed on July 4th, with a section that straight up takes the NFA's $200 tax on stuff like short-barreled rifles, short-barreled shotguns, and suppressors, and drives it down to zero. In our world, that is not some cute footnote. The entire legal excuse for the NFA has always been, relax, it's just a tax, based on a 1937 Supreme Court case. So when Congress kills the tax, everybody's thinking, no cap. The registry has got to be on life support. The DOJ does the opposite. But what we actually watched over the next few months was the exact opposite vibe from the DOJ. Instead of backing off or at least reevaluating how they defend old gun control laws in court, they kept showing up ready to protect the same NFA framework that Congress just punched a hole straight through. That gap between what we were sold and what the DOJ actually did, that's where this whole story starts. The first red flag. Here's where the first real red flag popped up for me with Bondi's DOJ. From day one, the entire legal justification for the NFA has been that it's a tax measure, upheld under Congress's taxing power, based on that 1937 Supreme Court decision. Back then, the $200 tax on short-barreled rifles, short-barreled shotguns, and silencers was serious money. That wasn't pocket change. Fast forward to this year. Congress passes the One Big Beautiful Bill and cuts those NFA taxes to zero. Not reduced, not adjusted, zero. So if the entire foundation is, this is a tax, and the tax is gone, anybody paying attention is thinking, all right, this thing should not be standing the same way in court anymore. That is exactly why a case like Silencer Shop Foundation versus ATF even exists. The moment that tax got wiped, smart lawyers looked at the old Supreme Court logic and said, there it is. That's the weak point. If no tax is being collected, the registry stops looking like a revenue tool and starts looking like pure gun control. Congress spells it out. Then you've got members of Congress sending the DOJ a letter spelling it out in plain English. They tell them the intent was to deregulate these items by killing the tax, and that the agency needs to respect that change from a separation of powers standpoint. That is Congress telling the executive branch, we changed the law, adjust your enforcement. What made guys like me stop and say, damn, something's off here, was how the DOJ reacted. Instead of pausing, instead of recalibrating, instead of acknowledging the new tax reality, they walked into court like nothing had changed at all, like the old tax justification was still fully alive. That was the first clear sign they were more interested in preserving the NFA machine than respecting what Congress just did. The mask comes off. When that DOJ brief finally hit the docket, I sat down and read it cover to cover, and it didn't take long to see the game. This was not some neutral housekeeping filing. This was a 48-page memo in Silencer Shop Foundation versus ATF, where the government is straight up asking the court to side with the ATF and keep the NFA structure intact as if nothing meaningful had changed. They attack standing. They claim the plaintiffs aren't really harmed. And they lean hard on the idea that the registry is still a valid use of federal power, even after Congress zeroed out the tax. You read it, and it's crystal clear. They walked in ready to defend the NFA, not rethink it. Shrugging off Congress. What really got my attention was how they talked about Congress and the tax repeal itself. Instead of treating the one big beautiful bill as a serious shift in policy, the DOJ basically shrugs and tells the judge, doesn't matter. They argue that wiping the $200 tax is irrelevant because Congress still has a general power to tax and regulate. That's a massive tell. They're trying to detach the NFA from the narrow 1937 tax logic that kept it alive and hook it into broader theories so it survives no matter what Congress does with the dollar amount. From a gun owner's perspective, that's dangerous thinking, because it means future registries can be sold as tax tools and then kept alive forever, even when the money side gets gutted. So when people call this a pro-Second Amendment DOJ, I point straight at that brief and say, read their own words. They're not acting like an agency that just had its authority clipped by Congress. They're acting like a department that thinks it can outlawyer both the Supreme Court precedent and the clear intent of the legislature. That memo is where the mask really came off. DOJ's wild claims. Now let's talk about how the DOJ described the guns themselves, because this part got real sketchy. They go out of their way to paint short-barreled rifles as concealable weapons likely to be used for crime. Like owning an SBR automatically puts you in the suspect column. Short-barreled shotguns? They tag those as tools that cause devastating damage at close range. Then they lump all NFA items together as weapons of war. That language sounds like it was ripped straight from a Moms Demand email blast, not from a DOJ that claims to be pro-Second Amendment. The issue isn't just the adjectives, it's the legal move behind them. The DOJ tells the court that the whole purpose of the NFA is to target dangerous and easily concealable weapons that criminals might use. On paper, that sounds narrow, but sit with it for 5 seconds. A compact 9mm with a standard magazine is dangerous and easy to conceal. A shockwave-style firearm, a braced pistol, a ton of home defense setups people rely on every day, all fit that label. That logic hands future courts a roadmap to bless bans on almost anything that isn't a full-size hunting rifle. So when I say this memo feels like a declaration of war on gun owners, I'm not talking about tone on social media. I'm talking about the federal government walking into court and handing judges language that treats our firearms like contraband by default. If that theory sticks, all they have to say next time is dangerous, easily concealable, and they're off to the races. That's why this filing matters. The hypocrisy. What really cooked it for me was the gap between how they talk on camera and how they argue in court. In public, it's all most pro-Second Amendment DOJ ever. Behind the scenes, they're leaning on the Ninth Circuit of all places to justify keeping a federal gun registry alive. The same Ninth Circuit that greenlit magazine bans, assault weapon bans, and had to be smacked down more than once on the Second Amendment. If you're truly protecting gun rights, that's not where you go shopping for legal language. In the memo, the DOJ grabs old cases that treat the NFA like a straight tax program and stretches them into a permanent permission slip. They tell the court that Congress's taxing power still exists in the background, so the registry stays valid even if the tax is zero. That's aggressive. The entire 1937 logic was built on raising revenue. Once there's no revenue, it starts looking like regulation for regulation's sake. Instead of admitting that, the DOJ basically says, trust us. The power is still there, so the structure rolls on. That's why I call this a betrayal. On the campaign trail, they talk tough on gun control. In federal court, where it actually matters, they're fighting to keep the NFA alive using the same playbook gun control states rely on. That's not an accident. That's a choice. And once you see it in writing, you can't unsee it. Why this could backfire? Now, here's where frustration turns into opportunity. No cap. Silencer Shop Foundation and the other plaintiffs didn't roll into court with some sloppy kitchen sink lawsuit. They built a tight tax clause case that lives or dies on one point. Congress dropped the NFA making and transfer tax to zero, but left the registration requirement running. That crashes head-on into the Supreme Court's own language from 1937, which upheld the NFA as a tax tied to real revenue, not a free-floating gun control code. If there's no meaningful tax being collected, the justification gets real shaky. Right now, both sides are pushing for summary judgment in the Northern District of Texas, which tells you this fight is about law, not messy facts. The plaintiffs are saying, read the statute as it exists today, line it up with the court's own words, and admit the tax clause can't carry this anymore. The DOJ is scrambling, pointing to other NFA-related taxes and broad regulatory power to plug the hole. If the court sides with the cleaner view that a tax has to actually be a tax, the registry and a big chunk of the NFA framework take a serious hit. This DOJ brief proves they are not the pro-Second Amendment ally they claim to be, but it also shows exactly where they're exposed. If Silencer Shop wins here, other NFA challenges are going to follow that blueprint and tighten it up even more. So yeah, I'm annoyed, but I'm also locked in on this case, because one ruling here could change how the NFA operates faster than any speech in DC ever will. Stay sharp, stay informed, and I'll see you on the next one.